all rise. Veuillez vous lever.
Please be seated.
The International Tribunal for the Law of the Sea is now in session. L'audience du Tribunal international du droit de la mer est ouverte.
Good morning. Welcome to the Tribunal. Pursuant to Article 26 of its statute, the Tribunal holds today a hearing in the case concerning the detention of 3 Ukrainian naval vessels between Ukraine and the Russian Federation. At the outset, I would like to note that Judge Eunjai, for medical reasons duly explained to me, is prevented from participating in this case. On 16th April 2019, Ukraine submitted to the Tribunal a request for the prescription of provisional measures pending the constitution of an arbitral tribunal in a dispute with the Russian Federation concerning the detention of 3 Ukrainian naval vessels. The request was made pursuant to Article 290, Paragraph 5 of the United Nations Convention on the Law of the Sea. The case was named Case Concerning the Detention of 3 Ukrainian Naval Vessels and entered in the list of cases of the Tribunal as case number 26. I now call on the Registrar to summarize the procedure and to read out the submissions of Ukraine.
Merci, Monsieur. Thank you, Mr. President. On the 16th of April 2019, a copy of the request for the prescription of provisional measures was sent to the government of the Federation of Russia. By order of the 23rd of April 2019, the President of the Tribunal set the dates for the hearing on the 10th and 11th of May 2019. By a verbal note of the 30th of April 2019, the Embassy of the Federation of Russia in Berlin informed the Tribunal that
the Federation is of the view that the arbitral tribunal to be constituted under Annex 7 of UNCLOS will not have jurisdiction, including prima facie, to rule on Ukraine's claim, in light of the reservations made by both the Russian Federation and Ukraine under Article 298 of UNCLOS, stating inter alia that they do not accept the compulsory procedures provided for in Section 2 of Part 15 thereof, entailing binding decisions for the consideration of disputes concerning military activities. Furthermore, the Russian Federation expressly stated that the aforementioned procedures are not accepted with respect to disputes concerning military activities by government vessels and aircraft. For this obvious reason, the Russian Federation is of the view that there is no basis for the International Tribunal for the Law of the Sea to rule on the issue of the provisional measures requested by Ukraine, and of quote,
In the same note verbal, the Federation of Russia informed the tribunal,
I quote, of its decision not to participate in the hearing on provisional measures in the case initiated by Ukraine without prejudice to the question of its participation in the subsequent arbitration if, despite the obvious lack of jurisdiction of the Annex 7 tribunal whose constitution Ukraine is requesting, the matter proceeds further. End of quote.
On the 2nd of May 2019, the registry of the tribunal received a communication in which, and I quote,
Ukraine requests, consistent with Article 28 of the Tribunal Statute, that the Tribunal continue the proceedings and render a decision on provisional measures. End of quote.
By order of the 2nd of May 2019, the President set the 10th of May 2019 as the date for the hearing. I will now read out the submissions from Ukraine. That's in the request from Ukraine.
In request that the tribunal indicate provisional measures requiring the Russian Federation to promptly a. Release the Ukrainian naval vessels, the Berdyansk, the Nikopol, and the Yanikapu, and return them to the custody of Ukraine. B. Suspend criminal proceedings against the 24 detained Ukrainian servicemen and refrain from initiating new proceedings. And C. Release the 24 detained Ukrainian servicemen and allow them to return to Ukraine. End of quote. Monsieur le Président.
Thank you, Mr. Registrar. At today's hearing, Ukraine will present its oral arguments. The sitting will last until approximately 1 p.m. with a break of 30 minutes in the middle. I note the presence at the hearing of the agent, counsel, and advocates of the applicant. I call on the agent of Ukraine, Ms. Olena Zerkal, to introduce her delegation.
Mr. President, members of the Tribunal, it is an honor for me to appear before this Tribunal presenting Ukraine. Let me begin by introducing the delegation of Ukraine. My name is Olena Zerkal, the Deputy Foreign Minister and Ukraine's agent. Present with me in the courtroom are Vice Admiral Andrei Tarasov, First Deputy Commander and Chief of Staff of Naval Forces of Ukraine, Ukraine's counsel and advocates Mr. Jonathan Gimblet, Professor Fred Sons, Ms. Marnia Chik, and Professor Jean-Marc Tovenen. Ms. Oksana Zolotaryova, Colonel Leonid Zalubovsky, Mr. Nikhil Gore, and Ms. Alexandra Francis are our counsel. Finally, Taras Kachka is our advisor.
Thank you, Ms. Zerkal. May I then request you to begin with your statement?
Thank you, Mr. President. With your permission, I will now introduce Ukraine's case. The dispute between the parties concerns the Russian Federation's unlawful and continuing seizure and detention of the Ukrainian warships Berdyansk and Nikopol and Ukrainian naval vessel Yanikapu on the 25th of November 2018 in the Black Sea. It is not just the ships that have been detained, but also the 24 Ukrainian servicemen on board. As a result of seizure and detention, Russia has violated the basic principle of the immunity of the warship under the United Nations Convention on the Law of the Sea. Ukraine has instituted an arbitration under Annex 7 of the Convention and seek relief for this violation. We appear before this tribunal today to ask you to exercise your power under the Convention, to prescribe provisional measures when the urgency of the situation so requires. Mr. President, members of the tribunal, Ukraine's naval ships continue to be held by Russia 6 months after they were seized, and the servicemen are under investigation and are detained in Lefortovo prison in Moscow. They are Captain of the 3rd rank, Volodymyr Lisovy, Captain of the 2nd rank, Denis Gritsenko, Captain Lieutenant, Sergei Popov, Senior Lieutenants, Andriy Drach, Bogdan Nebelitsa, Vasil Soroka, Lieutenant, Roman Makryak, Master Chief Petty Officers, Yuri Budzilo, Andriy Shevchenko, Petty Officers, Andriy Melnichuk, Vladislav Kostyshin, and Sergei Chuliba, Senior Seamen, Andriy Artemenko, Viktor Bespalchenko, Yuri Bezязичний, Андрій Оприско, Володимир Терещенко, Михайло Власюк, Володимир Веремес, В'ячеслав Зінченко, and seamen Андрій Айдер, Богдан Головаш, Євген Семидоцький, and Sergei Chibisov. These servicemen are charged with the criminal offense, violating the border of the Russian Federation. They are now under pretrial investigation. Their detention has been renewed twice by Russia's courts. The second time was only 3 weeks ago, 2 days after Ukraine submitted its request for provisional measures before this tribunal. This is just an additional illustration of Russia's continuing disrespect for international law. From the moment of the detentions, Ukraine has worked urgently to solve this matter. In keeping with Article 33 of the United Nations Charter, we gave Russia every opportunity to settle the issue by diplomatic means. We have worked through a variety of international fora to persuade Russia to respect its international obligations. But having made no progress, after several months of such efforts, and instead facing the detention of our servicemen being extended, we finally had no choice but to turn to judicial means of dispute resolution. Russia has ignored not only Ukraine's requests, but also numerous calls by international community, insisting that its actions are justified under its domestic law and under United Nations Convention of Law of the Sea. And now, Russia seeks to escape scrutiny of its unlawful actions by asking this tribunal to treat them as military activities, exempt from compulsory dispute settlement under the Convention, even though Russia has previously insisted that the events of 25th November were not a military confrontation. In fact, Russia's conduct constitutes a profound violation of the Convention and customary international law. Let me be clear. There is no question that Crimea is part of Ukraine and that the waters in which the seizure occurred constitute Ukraine's territorial sea or exclusive economic zone. But Russia's actions would violate Convention even if they had occurred in Russia's territorial sea or exclusive economic zone. The immunity of warships is a core sovereign immunity in the international system. Warships and their personnel can't be arrested by the law enforcement authorities of foreign state and subjected to the jurisdiction of foreign courts. Ukraine has come before this tribunal seeking urgent relief from ongoing harm under Articles 32, 58, 95, and 96 of the Convention and under customary principles of international law. Each additional day of detentions, each interrogation, each court appearance aggravates the dispute between the parties. This tribunal has previously said that a warship is the very, and here I quote, expression of the sovereignty of the state whose flag it flies, end of quote. And it has recognized that each day a warship is detained results in material and irreparable harm to the legal and practical interest of the flag state. As for the servicemen, this tribunal has more than once observed that, and here I quote, considerations of humanity must apply in the law of the sea as they do in other areas of international law, end of quote. Here, such principles require an immediate end to the separation of Ukraine's 24 servicemen from their families and their homes. The harm imposed on Ukraine, its naval vessels, and its servicemen is grave and grows with every day that passes. The situation is therefore exceptionally urgent. That is why Ukraine today asks the tribunal to grant provisional measures requiring that Russia promptly release Ukraine's naval vessels and its servicemen and return them to Ukraine. Mr. President, before asking that you give the floor to our Council team, may I express Ukraine's regret that the Russian Federation has once again decided not to fully participate in provisional measures procedures before this tribunal. The Russian Federation's decision not to participate in the hearing came as a surprise to Ukraine. After all, a Russian delegation participated in the pre-hearing phone call with the president of the tribunal on the 23rd of April. Russia's decision not to appear here today is regrettable. But this tribunal has previously had occasion to conduct hearings and award provisional measures against the Russian Federation, despite Russia's decision not to appear. That decision can't prevent Ukraine's ability to obtain international justice for its vessels and servicemen. As the tribunal stated in Arctic Sunrise, it must ensure that the other party is not, quote, put at a disadvantage because of non-appearance of the Russian Federation in the proceedings, end of quote. Mr. President, members of the tribunal, let me turn to the critical facts at hand. The warships Berdyansk and Nikopol and naval vessel Yanikapu and the 24 servicemen on board remain unlawfully in Russian custody and subject to Russia's jurisdiction. This situation can't continue without further irreparable harm to Ukraine's right. With your permission, our Council team will address why the situation satisfies the requirements for the grant of provisional measures under the Convention. Mr. Gimblett will provide brief factual background, including addressing events after Ukraine filed its request for provisional measures on 16th April. Professor Sons will describe the legal grounds for Ukraine's request and will also address the prima facie jurisdiction of an Annex 7 tribunal over the underlying dispute. Ms. Chik will respond to Russian Federation military activities argument. Finally, Professor Tovanin will address the appropriateness of provisional measures in this case and the specific elements of harm and urgency. Mr. President, I respectfully ask you to call Mr. Gimblett to the podium. Thank you.
Thank you, Ms. Zerkal. I now give the floor to Mr. Jonathan Gimblett to make the next statement for Ukraine.
Mr. President, members of the Tribunal, it is an honor to appear before you on behalf of Ukraine. I will describe the facts giving rise to Ukraine's claim before other members of our team explain how those facts support the prescription of provisional measures by this tribunal. I will also provide some additional factual background in response to the memorandum of the government of the Russian Federation dated 7th of May 2019. I will refer during the course of my presentation to a slide deck that can be found at the first tab in your binders and which will be projected simultaneously on the screens. The essential facts of this case are not in dispute. On the 23rd of November 2018, on the 25th of November 2018, two small Ukrainian warships, the Berdyansk and the Nikopol, and a naval auxiliary vessel, a tugboat named the Yanni-Kapu, were seized and detained by ships of the Russian Coast Guard. The seizure took place in the Black Sea to the south and west of the entrance to the Kerch Strait. The relevant maritime area is shown on the map at page 1 of the slide deck and now on the screens. A report published by Russia's Federal Security Service, the FSB, records that the Ukrainian vessels were in the Black Sea and traveling away from the Crimean coastline at the time of the seizure. The Ukrainian Navy has also submitted a report with Ukraine's request for provisional measures, which can be found at tab 3 in your binders. As that report explains, Ukraine does not have precise coordinates for the boarding of the vessels, either because the vessels did not have the opportunity to transmit their position, or because the Russian Federation jammed the relevant transmissions. While both the FSB report and Russia's memorandum of the 7th of May are silent on the subject, the Ukrainian Navy estimates, based on transmissions sent before the seizures, that the Berdyansk and the Yanni-Kapu were seized at a distance of approximately 12 nautical miles from the coast, and the Nikopol at a distance of approximately 20 nautical miles from the coast. The separate declaration provided by Vice Admiral Andriy Tarasov, which you can find at tab 4 in your binders, explains the basis for the Ukrainian Navy's estimates in more detail. The estimated locations of the seizures are shown on the map now on your screen. After the seizure, the vessels and the 24 servicemen on board them were transported to the port of Kerch, a Russian-occupied port on the eastern coast of Crimea, which is also shown on the map. On the next slide, an AFP press photograph shows the three vessels in Russian custody at Kerch, with what appear to be Russian officials on board the Nikopol, which is the vessel marked P-176. Russian government documents show that the servicemen were charged with the criminal offense of a crossing of the state border of the Russian Federation without obtaining appropriate permission as part of an organized group. For example, now on the screen, you can see the indictment in the case of senior seaman Andriy Anatolievich Artemenko, with underlined text reflecting the charge. As indicated in the same indictment, and shown on this slide, the Russian Federation contends that this alleged crossing violated Article 3223 of Russia's Domestic Criminal Code. Other documents reflecting these charges include the order on opening a criminal case and commencing criminal proceedings at tab 7 in your binders, which was submitted as Annex A, Appendix D to Ukraine's request, and the court documents submitted as Annex C, Appendices 1 and 2 to Ukraine's request. Based on these charges, the Russian Federation is holding the 24 servicemen at the Lefortovo prison in Moscow, a detention center of the Ministry of Justice of the Russian Federation. While in detention, the servicemen have had access to consular officials and Russian lawyers, although their meetings with consular officials have been monitored by the Russian authorities. However, they have been allowed no other visits, even from family members, and as described in the news article appearing at tab 9 in your binders, it was only after this case was filed that Russia even allowed the sailors to call home for the first time. In his declaration at tab 6, Mr. Nikolai Polosov, the Russian attorney for the most senior officer among the servicemen, reports that the servicemen have repeatedly been interrogated, that they have been subjected to psychological evaluations, that they have been exposed to so-called non-procedural questioning by Russia's FSB outside the presence of counsel, and, as reflected in the press photograph now on the screen, that they have been displayed to the media in public court appearances as though they were common criminals. The purpose of those court proceedings has been to extend the detentions of the servicemen and therefore of the vessels which are being held as evidence in the case against the servicemen. 2 such extensions have been granted to date. Most recently, shortly after Ukraine filed its request, a district court in Moscow issued orders on the 17th of April 2019, extending the detentions until late July. On the 8th of May 2019, Ukraine submitted to the tribunal the relevant district court decision as to 4 of the servicemen, which was obtained from Mr. Polosov. The decision appears at tab 8 of your binders. This recent hearing demonstrated the gravity and the urgency of the situation precipitated by Russia's detention of the vessels and servicemen. The court documents submitted by Ukraine on the 8th of May confirmed that Russia will further violate the immunity of the vessels by subjecting them to ongoing investigations and forensic examinations. Those documents also make clear that Russia will continue to push forward with civilian interrogations and investigations, and with its plan to prosecute the servicemen, subjecting them to a maximum sentence of 6 years in a Russian labor camp. These, then, are the facts upon which Ukraine bases its claim. As I mentioned at the outset, none of them are in dispute between the parties. In its memorandum of 7th of May, however, Russia has raised a number of allegations about the events preceding the seizure and detention of the vessels. To be clear, the dispute Ukraine has submitted to arbitration, and that is now before this tribunal, concerns only Russia's exercise of jurisdiction over the 3 Ukrainian vessels in spite of their complete immunity. That includes both the seizure and detention of those vessels and the subsequent civilian legal process to which both the vessels and those on board have been subjected. Russia's version of what happened in the hours leading up to the seizure and detention is simply not relevant to the immunity of the Ukrainian vessels at the time they were seized. Nonetheless, in order to correct the record, I will briefly respond to certain of Russia's contentions. First, in its memorandum of the 7th of May, Russia describes the mission of the 3 Ukrainian naval vessels as a secret incursion into Russian territorial waters. That is simply not the case. The mission of the vessels was to navigate from the Ukrainian port of Odessa to the Ukrainian port of Berdyansk on the northern shore of the Sea of Azov, where they were thereafter to be permanently stationed. Other Ukrainian naval vessels had successfully completed the same transit as recently as September 2018, just 2 months earlier. On the slide now on the screen, you will see a general area map that reflects the location of both ports, Odessa and Berdyansk, and of the Kerch Strait. Russia refers to a document found on board the Nikopol, guiding them, in Russia's translation, to sail covertly outside of the coastal and maritime regions of patrol of the Black Sea Fleet of Russia and the Coast Guard of the FSB of Russia. Vice Admiral Tarasov confirms that the purpose of this guidance was to avoid unnecessarily provoking incidents with Russian government vessels during the 2 days it would take to reach the Kerch Strait from Odessa. Nor can the guidance be read as suggesting that the mission of the naval vessels was to transit the Kerch Strait secretly, an impossible task given the breadth of the Kerch Strait and the navigable channels through it. Indeed, as the Ukrainian Navy report at tab 3 confirms, as it approached the Kerch Strait, the Berdyansk radioed both a post of the Russian Border Guard Service and the port authorities at Kerch and Kavkaz ports to announce the intention of the 3 vessels to proceed through the Kerch Strait. Second, in its memorandum, Russia invokes the allegedly crowded conditions in the Kerch Strait on the 25th of November as a justification for the actions taken by its Coast Guard. Again, the Russian account is full of holes and cannot be relied upon. The Kerch Strait regularly handles significant traffic in commercial vessels. The slide now on your screen, for example, shows a snapshot of the traffic through the Kerch Strait and to and from the Ukrainian and Russian ports on the Sea of Azov on the 7th of May. According to Russia, its Coast Guard warned the Ukrainian naval vessels on the night of the 24th of November of a temporary suspension of the right of innocent passage for naval vessels in the approach to the entrance to the Kerch Strait due to an expected storm. But as the Ukrainian Navy report and the declaration of Vice Admiral Tarasov establish, the Ukrainian Navy was unable to find any evidence of such a restriction where it would normally be posted online. Russia's version of events also fails to mention that, as widely reported in press coverage of the events of the 25th of November, and reflected in the press photograph now on the screen, a tanker was positioned across the span of the Kerch Strait Bridge on the 25th of November, blocking all traffic through the strait, not just that of naval vessels. Finally, if the strait had been as crowded by vessels carrying dangerous cargo as Russia now claims it was at the time of these events, it would not have been possible for Russian Coast Guard vessels to engage in a high-speed chase and to fire their guns in the direction of the Ukrainian vessels without risking civilian injury or death. Third, Russia accuses the Ukrainian naval vessels of what it calls provocative actions. These include the allegation that the Nikopol and Berdyansk were put in a condition of combat readiness with guns uncovered and elevated. The suggestion that these two small and lightly armored Ukrainian vessels were in a position to threaten the numerous Russian government vessels in the area in this way is, on its face, not credible. As the Ukrainian Navy report and Vice Admiral Tarasov's declaration establish, the vessels were under orders to proceed peacefully and to abstain from any aggressive acts. There is no indication that they did otherwise. Vice Admiral Tarasov points out that sailing with uncovered guns is entirely consistent with Ukrainian standard operating procedure, just as it is with Russia's own standard operating procedure. And given the proximity of the Russian Coast Guard vessels, the raising of guns to an elevation of 45 degrees should and would have been interpreted by those vessels as signaling the absence of aggressive intent. Had the guns been fired at that elevation, the shells would have traveled far above and beyond the Russian vessels in the vicinity. As I said previously, though, none of these incorrect factual allegations by Russia are pertinent to your consideration of Ukraine's claim, which concerns only Russia's exercise of jurisdiction over the Ukrainian vessels and servicemen, beginning with their seizure and detention on the 25th of November 2018. Even if these Russian allegations were true, which they are not, the undisputed facts of this case would still give rise to a clear and continuing breach of the Convention and an urgent situation meriting provisional measures to preserve Ukraine's rights. With the Tribunal's permission, I will now cede the podium to Professor Soanes to address the legal grounds for Ukraine's claim and the Tribunal's prima facie jurisdiction.
Thank you, Mr. Gimblett. I now give the floor to Mr. Alfred Soanes.
Mr. President, members of the Tribunal, it is an honor for me to appear before you on behalf of Ukraine in this important case. My task today will be to set out the legal grounds for Ukraine's request for provisional measures, and then to show that the legal grounds Ukraine invokes prima facie afford a basis for the jurisdiction of an Annex 7 tribunal. Thereafter, I will show that Ukraine has complied with the requirements of Sections 1 and 2 of Part 15 of the Convention in connection with the underlying dispute. So first, the legal grounds. Ukraine's request for provisional measures is intended to protect its rights under the Convention and customary international law to complete immunity of its warships, naval auxiliary vessels, and all persons on board from the jurisdiction of any other state. Warship immunity is a fundamental and long-standing tenet of the law of the sea. And as I will explain further, the rights Ukraine seeks to protect meet and exceed the standard of plausibility applied at the provisional measures stage. As this tribunal explained in its provisional measures order in the ARA Libertad case, a warship and any other vessel assigned to the public service of national defense, I quote, is an expression of the sovereignty of the state whose flag it flies, unquote. Several articles of the Convention entitle such ships to complete immunity from seizure, detention, and legal process. In particular, Articles 95 and 96 of the Convention provide that warships and ships owned or operated by a state and used only on government non-commercial service, of which naval auxiliary vessels are the classic example, enjoy complete immunity from the jurisdiction of any state other than the flag state. Article 58 extends the application of the immunity under Articles 95 and 96 to the exclusive economic zone. And Article 32 and customary international law guarantee the same immunity in the territorial sea. In short, wherever in the seas a naval vessel may be found, the Convention requires that it be accorded complete immunity from the jurisdiction of all states other than its flag state. The immunity of warships, as a specific application of the principle of state immunity, has been established since at least the early 1800s. It is often pointed out that the doctrine was recognized more than 2 centuries ago in the 1812 decision of the United States Supreme Court in the famous Schooner Exchange versus McFadden case, and is also reflected in other venerable judgments, such as the 1880 decision of the Court of Appeals of England and Wales in the Le Parlement Belge case. Both these authorities analogize the immunity of warships to the equally fundamental and long-standing rule of diplomatic immunity. More recently, the 1958 Geneva Conventions on the Territorial Sea and Contiguous Zone and on the high seas recognized and confirmed the customary immunity of warships and other non-commercial government vessels. Like the Law of the Sea Convention, the Convention on the Territorial Sea and Contiguous Zone provided in Article 22 that nothing in it would affect the immunities which government ships enjoy. And similarly, the Convention on the High Seas specified in Articles 8 and 9 that warships and government non-commercial vessels have complete immunity from the jurisdiction of any state other than the flag state. This rule of complete immunity for warships and other governmental vessels is recognized not only in treaties relating to the law of the sea, but also in other relevant international instruments. For example, while allowing for legal process against government vessels on commercial service, Article 16, paragraph 2, of the United Nations Convention on Jurisdictional Immunities of States and Their Property categorically excludes jurisdiction over, and I quote, warships or naval auxiliaries and other vessels used only on government non-commercial service. Not surprisingly, given that the Russian Empire, the Soviet Union, and the Russian Federation have all maintained substantial naval forces in the Pacific, the Baltic Sea, the Black Sea, and further afield, Russia has long benefited from the rule of complete immunity. The Soviet Union, for example, asserted immunity to protect warships, including submarines, operating both in international waters and in the territorial sea and internal waters of other states, such as in the well-known case of the Soviet submarine that ran aground in Swedish internal waters in 1981, which I will return to in a few minutes. Even today, the Russian Federation continues to operate its warships far from home, something that is only possible because of the immunity of warships and the naval auxiliary vessels that support them. It is unsurprising, therefore, that Russia has been a strong advocate for such immunity, supporting the provisions on the immunity of governmental vessels in the 1958 Geneva Conventions, and even suggesting that they be expanded to cover governmental ships on commercial service. What precisely, then, does the rule of complete immunity protect? And what obligations does it entail for third states? As for the first question, the rule of complete immunity protects the ships themselves, as well as their crews, their passengers, and all others aboard them, and even goods and equipment on board. This follows directly from the jurisprudence of this tribunal. In its judgment in the motor vessel Saigon No. 2 case, for example, this tribunal recognized that the convention considers a ship as a unit, comprised of not only the ship itself, but also its crew, every other person on board the ship or otherwise involved or interested in its operations, and the ship's cargo. Oppenheim's international law states the case in even stronger terms, referring specifically to the fact that the immunity of a naval vessel takes precedence over the criminal jurisdiction of the coastal state with respect to the vessel and all persons it carries. I will quote the relevant passage from Oppenheim as it's shown on the screen, but it's a long passage. I will read it because it's useful to have it in mind. I quote, "A warship with all persons and goods on board remains under the jurisdiction of her flag state even during her stay in foreign waters. Members of the crew who commit crimes when ashore and then return to the vessel may not be seized by the authorities of the littoral state, who can only request their surrender. If the request is granted, the local courts have jurisdiction to try the offender, but not if it is refused or if it is granted on conditions which exclude the exercise of jurisdiction. Individuals who are subjects of the littoral state and are only temporarily on board may, although they need not, be taken to the home country of the vessel to be punished there if they commit a crime on board. Even individuals who do not belong to the crew, but who, after having committed a crime on the territory of the littoral state, having taken refuge on board, cannot be forcibly taken off the vessel. If the commander refuses their surrender, it can be obtained only by diplomatic means from his home state." Unquote. As for the second question, what obligations does the rule of complete immunity entail for states other than the flag state? Again, the answer is well established. As implied by the term complete immunity, other states are obliged not to take any action that physically or legally encumbers the vessel. Thus, they must not board such a vessel, arrest it, detain it, or otherwise prevent it, in the words of the ARA Libertad Provisional Measures Order, from, I quote, discharging its mission and duties, unquote. Further, as suggested by the passage from Oppenheim's, just quoted, two, other states must not purport to subject the vessel or any person or thing on board to any form of civilian legal process. Notwithstanding the complete immunity from the exercise of jurisdiction, the Law of the Sea Convention accords to warships and other governmental vessels. Russia's Coast Guard has wrongly suggested that its attempt to prevent the return of the vessels to Odessa and its ultimate seizure of the vessels was consistent with the convention. Specifically, in a report published on its website and reproduced at tab 5, page 4, the FSB Coast Guard stated, and I quote from this report, "At 6:30 p.m., the group of Ukrainian naval vessels attempting to break through the blockade made sail and started moving at a course of 200 degrees. That is a south-southwest direction, heading out of the territorial sea of the Russian Federation. The artillery ships Berdyansk and Nikopol were moving at a speed of 20 knots and the seagoing tugboat Iana Kapu at 8 knots. The border patrol ships Don and Izumrud started following the group of Ukrainian naval ships and communicated to them in order to stop." And then it says, between brackets, "in accordance with Article 30 of the UN Convention on the Law of the Sea of 1982 and Article 12, paragraph 2 of Federal Law 155, dated July 31, 1998, on the internal seas, territorial sea, and contiguous zone of the Russian Federation. End of quote. Now, for the avoidance of doubt, Ukraine, of course, does not accept that the area of sea within 12 miles of the coast of Crimea is the territorial sea of the Russian Federation. However, and contrary to Russia's position at footnote 58 of its memorandum of 7 May, the identity of the coastal state is not a question that this tribunal, or even the Annex 7 tribunal, still to be constituted, would need to resolve. Even if one were to posit that the vessels were in a Russian territorial sea, Article 30 does not permit the Coast Guard of a littoral state to issue a foreign naval vessel with an order to stop. To the contrary, the exclusive right accorded to the Russian Coast Guard under Article 30 would have been to require the vessels to leave the territorial sea. Something, and it is important to emphasize this, that the report acknowledges that the vessels were already in the process of doing. In claiming to rely on the Law of the Sea Convention's Article 30, Russia overlooks the fact that Articles 30 and 31, now shown on the screen, of the Convention serve to confirm the complete immunity of warships and other governmental vessels from foreign jurisdiction. They provide as the exclusive remedies for a coastal state in connection with a foreign naval vessel's non-compliance with its laws and regulations, that a coastal state is permitted under Article 30 to require a warship to leave the territorial sea immediately, and that, pursuant to Article 31, the coastal state may subsequently seek compensation from the flag state for any damage caused by the warship. Indeed, even before the adoption of the Convention, it was well established under Article 23 of the Convention on Territorial Sea and Contiguous Zone and customary international law that the only remedy against the warship for claimed non-compliance with the rules on innocent passage was to request that the warship leave the territorial sea. I would note that Russia itself has relied on this rule to its benefit. In the 1981 submarine incident in Swedish waters, I referred to a few minutes ago, the Soviet Union reportedly submitted a diplomatic note to the Swedish government invoking, and I quote, the generally recognized principle of international law under which a warship enjoys complete immunity from the jurisdiction of any state other than the one under whose flag she is sailing. And the note continued, even if a foreign warship fails to observe a coastal state's rules on passage through its territorial waters, the only thing the coastal state may do is demand that she leave its waters. Mr. President, members of the Court, of the Tribunal, it is therefore apparent that while Russia claims to have complied with the Convention, it has in fact violated the immunity of Ukraine's naval vessels and the servicemen on board by seizing them, exercising its jurisdiction over them, and continuing to do so up to the present day. As Mr. Gimlet just described, since the seizure, Russia has compounded its violations of the Convention and aggravated the dispute between the parties by, among other things, conducting on-board investigations of the Berdyansk, Nikopol, and Yanikapu in plain violation of those vessels' immunity under the Convention, and violating the corresponding immunity of the servicemen on board those vessels by arresting them, initiating and pursuing civilian legal proceedings against them, detaining them in Russian prisons, and repeatedly subjecting them to interrogations, psychological examinations, and legal process. Each additional day of detention, each interrogation, each involuntary psychological examination, and each court appearance compounds Russia's violation of the immunity guaranteed to Ukraine's naval vessels under Articles 32, 58, 95, and 96 of the Convention. Mr. President, members of the Tribunal, having set out the legal grounds for Ukraine's request, I will now turn to showing that prima facie an Annex 7 tribunal would have jurisdiction over the underlying dispute between the parties. Ukraine has invoked provisions of the Convention that appear prima facie to afford a basis for the jurisdiction of the Annex 7 tribunal, and Ukraine has complied with the remaining requirements of Sections 1 and 2 of Part 15 of the Convention, including the obligation to exchange views under Article 283. As a consequence, this tribunal is competent to prescribe provisional measures under Article 290, paragraph 5. Let me begin by recalling that Article 290, paragraph 5 of the Convention provides that this tribunal is competent to prescribe provisional measures in connection with a dispute, and I quote, if it considers that prima facie the tribunal which is to be constituted would have jurisdiction, end of quote, over the dispute. And that tribunal, in our case, means the Annex 7 tribunal to be constituted. In its most recent provisional measures order, in the Enrica Lexi case, this tribunal explained that this jurisdictional requirement is satisfied so long as, and I quote, any of the provisions invoked by the applicant appears prima facie to afford a basis on which the jurisdiction of the Annex 7 tribunal, arbitral tribunal, might be founded, unquote. Here, Ukraine has invoked Article 32 and, through Article 58, paragraph 2, Articles 95 and 96 of the Convention. And, as just described, the parties are plainly engaged in a dispute over the interpretation and application of those articles. In Ukraine's view, Russia's seizure and continued detention of the naval vessels, as well as its criminal prosecution of the vessel's servicemen, violate the principle of warship immunity under these articles. Russia, however, has maintained that its actions are lawful under, among other provisions, Article 30 of the Convention. It is this difference of views that the Annex 7 tribunal would have to resolve, and that it will have the competence to resolve under Articles 286 and 288 of the Convention. Mr. President, members of the Tribunal, in addition to being a dispute concerning the interpretation or application of the Convention under Articles 286 and 288, the dispute submitted by Ukraine meets the remaining conditions for the jurisdiction of an Annex 7 tribunal. Ukraine's written request and the notification appended to Ukraine's request set out the basis for this conclusion. Ukraine and Russia are both parties to the Convention. Both Ukraine and Russia have selected Annex 7 arbitration as the means of settling disputes, such as this one, pursuant to Section 2 of Part 15 of the Convention. And prior to submitting the notification, Ukraine satisfied the requirement in Article 283 that the parties to the dispute, I quote, proceed expeditiously to an exchange of views regarding its settlement by negotiation or other peaceful means, unquote. Russia, of course, in its 7 May memorandum, denies that Article 283 has been satisfied. But its argument is simply incorrect. Article 283, paragraph 1, shown on the screen, provides that, quote, the parties to the dispute shall proceed expeditiously to an exchange of views regarding its settlement by negotiation or other peaceful means. This obligation to exchange views is simply that. As this tribunal has observed in its provisional measures order in Arctic Sunrise, and I quote, a state party is not obliged to continue with an exchange of views when it concludes that the possibilities of reaching agreement have been exhausted, end of quote. A view consistent with its previous decisions. And as the Annex 7 Tribunal determined, in concurring with this tribunal's view that Article 283 had been satisfied in the circumstances of the Arctic Sunrise case, and here I quote, the parties' exchange of views regarding the means by which a dispute that has arisen between them may be settled. Negotiation is evoked as one such means, arbitration is another. Article 283, paragraph 1 does not require the parties to engage in negotiations regarding the subject matter of the dispute. End of quote. Here, in our case, on March 15, 2019, Ukraine transmitted a diplomatic note to the Russian Federation indicating its preference that the dispute be resolved through Annex 7 arbitration and requesting an exchange of views pursuant to Article 283. In light of the urgency of this situation, Ukraine insisted that this exchange of views take place within 10 days. Contrary to Russia's argument, this 10-day deadline was not arbitrary. It reflected the facts that each passing day further compounded the harm to Ukraine's rights, and that Ukraine had already, over a period of months, repeatedly protested the detention of the vessels and servicemen and sought their release. Russia acknowledged receipt of Ukraine's diplomatic note 10 days later, on the 25th of March, 2019. However, Russia did not even attempt to exchange views with Ukraine within this time frame, nor did it provide any explanation of why it could not do so. Instead, as shown at tab 13 in your folder and on the screen, Russia simply stated that possible comments on Ukraine's note of 15 March were, I quote, expected to be sent separately, leaving it entirely ambiguous whether and when Russia would ultimately agree to participate in an exchange of views. It was only on April the 12th, 4 weeks after Ukraine's request for an exchange of views, that Russia finally accepted Ukraine's request. Tab 14 in your folder. Despite the delay, Ukraine promptly responded to Russia's diplomatic note, see tab 15, and arranged a meeting between the parties on the 23rd of April 2019 in The Hague. By this time, on April the 1st, Ukraine had filed its notification under Annex 7, including a request for provisional measures, but Ukraine remained interested in exchanging views regarding possible means of settlement of the dispute. At the same time, Ukraine could not accept further delay of implementation of the requested provisional measures. Accordingly, Ukraine filed its request for provisional measures from this tribunal on April 16. At the meeting between the parties on the 23rd of April, the Russian Federation failed to make any concrete proposals to resolve the dispute or to secure the prompt release of the servicemen or vessels. Instead, the Russian Federation proposed additional consultations between the parties under Article 283 and also asked Ukraine whether it had considered joining the present case to the ongoing Annex 7 proceeding between the parties. In response to Russia's suggestion of additional consultations, Ukraine asked the Russian delegation whether Russia had any specific objectives or requests for Ukraine to consider as part of such consultations. The Russian Federation was unable to provide any. Accordingly, Ukraine indicated that further consultations were not likely to be fruitful and were not appropriate, given, among other things, the urgency of the situation precipitated by Russia's actions. In connection with Russia's question regarding joinder of these proceedings, Ukraine explained that the ongoing Annex 7 case involves an entirely different subject matter from the present dispute concerning warship immunity, and attempting to combine those two completely separate disputes at this stage would not be efficient. Notably, the delegation of the Russian Federation did not indicate that Russia itself viewed joinder of the two disputes to be appropriate, or indeed even legally possible. Ukraine confirmed its view that a separate Annex 7 arbitral proceeding is the proper way to settle this distinct dispute. It should be apparent from this account of events, Ukraine's obligation to exchange views was satisfied on the 25th of March 2019. Article 283, paragraph 1, requires the exchange of views to take place expeditiously, and in simply ignoring Ukraine's proposed schedule for an exchange of views, Russia failed to comply with that obligation. When it received Russia's note of the 25th of March 2019, Ukraine could not have foreseen that Russia would, weeks later, agree to Ukraine's request for a meeting, and Ukraine was entitled to presume that further attempts to seek negotiations would not be fruitful. Ukraine was not required to indefinitely postpone its case and allow further harm to its rights. To the extent the tribunal considers that the parties were still under an obligation to exchange views after the 25th of March, however, Ukraine's 23rd of April exchange of views with the Russian Federation satisfies the requirements of Article 283. Again, under the plain text of the article, the only obligation imposed by Article 283 is for each party to put forward its views on, and to try to agree on, the appropriate process for resolution of the dispute. That obligation was satisfied, at least on Ukraine's part, on the 23rd of April meeting, and, for that matter, also through the diplomatic notes that preceded the meeting. In sum, Ukraine has satisfied the requirements of Article 283 in this case. Mr. President, members of the Tribunal, having described the provisions of the Convention that apply to this case, and that Russia continues to violate even today, and having shown that the dispute submitted by Ukraine satisfies, prima facie, the requirements of Sections 1 and 2 of Part 15 of the Convention, I now conclude my portion of Ukraine's oral submissions. With your permission, Mr. President, possibly after the break, Ms. Marnie Cheek will address the remainder of Ukraine's case on jurisdiction, and specifically its response to Russia's arguments under the Military Activities Clause in Article 298, paragraph 1, sub b. Mr. President, members of the Tribunal, I thank you for your attention to my presentation.
Thank you, Mr. Suns. We have now reached 11:10 a.m. At this stage, the Tribunal will withdraw for a break of 30 minutes. We will continue the hearing at 11:40 a.m.
All rise. Veuillez vous lever.